Ladies and gentlemen, good afternoon. It's a pleasure to be here today in our webinar dedicated to the IP and how to use IP in the commercial contract. We have with us today our representative of Chongqing office, Mr. Shane Farley. I'm really pleased to have you here in our Shanghai office. And you will bring us through your presentation. At the end, we will have a session of the Q&A, and we will have the pleasure to share thoughts among our participants all around the world. Thank you so much, and I give the word to our Shane.
Firstly, thank you, Carlo, for the kind words and the introduction. Just firstly, is everyone okay with the audio? Is everything clear? Okay. If possible, could you mute your microphone so the sound is more clear? Or we just do like this? Okay, so as a general introduction in collaboration with what Carlo had said, I'm Shane Farley from our Chongqing office of DP Group, and today, as well as introducing DP Group, I will be presenting how to effectively protect a company's intellectual property within commercial contracts in China. So as a start, we'll look at DP Consulting Group and then move on gradually to the topic at hand. So firstly, our DP Group's core values are centered around our clients in terms of providing our clients the best service in the fastest way. So this core value stretches throughout our core ideologies, which incorporate not only our clients' best interests, but also the interests of our employees and constant growth and providing growth to not only our clients, but our employees as well. And I believe actually this is all very familiar to all attendees, so I'll briefly go through this content and then we'll get to the webinar topic at hand. So our DP Group are focused initially on investment and consulting firm and then on to full service. The composition of our firm, introduction of P.R.C, one of the arms of our firm for tax advisory and financial services, E-Stand for marketing and events, our newest company, Chance & Better, for education consultancy, and of course, DeAndre & Partners Legal Counsel. We will see these are some of the main services our legal counsel provides, as well as our practical guides, which not only assist our friends and clients with practical advice in investing in foreign markets, but also specific areas of interest in terms of IPR, which we'll touch on today. So these are the addresses and contact information of our offices. So finally, to the topic at hand, how to effectively protect intellectual property rights within commercial contracts, as well we'll see in terms of other types of contracts which a company will be engaged in its day-to-day business. So I previously presented this around China before, and it's gained great interest, so we thought we'd present it to friends and clients in the form of a webinar, so hence the occasion today. So firstly, we'll see how we'll break down the general topic today. So we'll look at the crux of the question: why specifically in contracts should a company seek to protect its intellectual property? Secondly, within those contracts, which intellectual properties should a company look to protect? And then finally, we'll look at example clauses within those commercial contracts and how we would seek to protect the company's intellectual property. Okay, so this is the general overview. Okay, so firstly, why specifically in contracts should a company protect its IPR? Well, firstly, it's a preventative measure in terms of a company will be engaged in a multitude of contracts in its day-to-day business. This is generally to add an extra layer of protection to a company's ongoing business, as well as, of course, if a company is engaging in a foreign environment, of course, registering their intellectual property rights, or rather extending their registration to the foreign invested country rather, is of paramount importance, as the company's intellectual property is most sensitive when investing in a foreign country. Thirdly, in terms of the country's image as well as its reputation, if you think about the trademarks as well as the trade secrets of a company, these are really what differentiate a company from its competitors, as well as why certain clients or customers come to a company rather than other companies. So any infringement or damage to a company's intellectual property would greatly damage its public image, and perhaps irreparably so. So finally, we'll look at some commercial contracts today where the company's intellectual property is at risk from external factors, but additionally, some of the intellectual property of a company will also be at risk from internal factors of the company. So we'll look at how information leaking from inside the company can also lead to damage to the company's business in terms of its intellectual property. So these are the why behind the question, and now we'll look at what we can effectively protect within these commercial contracts and other contracts, which we will look at a bit later. So we will look at, of course, copyright, patents, trademarks, as well as trade secrets, and how these will be implemented and protected within intellectual property protective clauses in commercial contracts. So these are some of the commercial contracts we'll look at today: trademark licensing contract, distribution contract, as well as OEM supply contracts, which these are maybe, apart from the trademark licensing contract, very general contracts in which a company will be engaged in its day-to-day relations with clients, suppliers, manufacturers, such like this. But for employment contracts, as I mentioned before, this is where the intellectual property will be at risk from internal factors. So we'll see how this factors into protecting the intellectual property of the company. So firstly, for trademark license agreements, of course, this is where a trademark owner would license out the use of their trademark to licensees in order to make and distribute products within a certain area for a certain time. Of course, for these sort of agreements, the trademark owner would get some sort of reimbursement for licensing out their trademark, whether it be a lump sum payment, royalties. Generally, the rights and liabilities of both parties within a trademark license agreement would differ depending on the different types of agreement, trademark license agreement rather, decided between the two parties. So we'll firstly look at the different types of trademark license agreement and how it differs the relationship between the parties. So firstly, for exclusive licenses, this is where the commercial rights of the trademark are sold outright to the licensee for a lump sum payment. But generally speaking, these are for a specified amount of time or a very specific product or service. Under the sole license, both licensee and licensor would have commercial rights underneath the license agreement, and as the name suggests, the non-exclusive license would give licensee, licensor, as well as any third party assigned rights under the license. So in speaking about trademark license agreements, generally these sort of agreements would have IPR at the crux of the agreement. So even though the IPR is being licensed out to another party, we'll see how the trademark owner can still rein in some amount of control back to their intellectual property underneath the license. So we would advise in adding clauses for the approval of all marketing and promotional material of the licensed out trademark, the specific conditions for the renewal of such a license agreement, as well as whether or not it would be shared with any third party, as we see in the non-exclusive license agreement. Additionally, the terms of which will be specified upon the termination of the license agreement, what would happen to both parties upon termination, as well as should either party breach the license agreement, what sort of penalties, as well as the specific time frame in which such penalties should be remedied. So again, as I mentioned, the trademark license agreement, maybe it's a bit too specific in terms of intellectual property. So we'll look at more general contracts which a company will be engaged in, such as employment contracts, distribution contracts, and how to effectively protect intellectual property rights within them. In speaking of that, employment contracts, again, not specifically commercial contracts, but we see in our practice, of course, that even in employment contracts, companies' intellectual property are very much at risk from even their own employees. So from internal relations of the company, if you think about especially key employees or employees that are engaged in the R&D, design, or have access to sensitive financial information of the company, if there are no protective clauses within their employment contract, then if they leak that information to the public or to competitors, then it can be very much damaging to the future business of their former employer. So we would advise to add supplementary agreements. I'm sure everyone's fairly familiar with these concepts. Supplementary agreements in terms of confidentiality, as well as non-competition agreements to the contracts. These are very general and supplementary agreements to employment contracts, especially where the employee would have access to sensitive information of their employer or company. Additionally, in terms of employees that will be engaged in the R&D or product design, we would also advise to add clauses on copyright of design as well as patent right of invention, so as any patentable rights that an employee would potentially gain within their employment would be forfeit and would be the property of the employer as opposed to the individual employee. Now these are our suggestions, and we'll look at some example clauses and see how they can effectively protect the employer's intellectual property, and we'll have a look at how they can be implemented into employment contracts. So in terms of confidentiality clauses, we'll see that an employee, when engaging with any confidential information, and we'll see how that's defined in a little bit, in terms of any of the sensitive information in terms of technology, marketing, sales, or financial, their information, anything to do with the products or the internal business of the company, they must keep strictest confidence and must not disclose directly or indirectly to any person outside of the company, or any of the information in terms of the parent company of their employer or any businesses which are related to their employer. So it's very, very far-reaching actually. So again, not to disclose any person outside of the company. Essentially, the employee, we see on the last line here, would only use the confidential information as defined for the use of their employment duties underneath their employment contracts. So essentially, all confidential information which they would be privy to during their employment would be solely for the usage of their job and for no other purpose. Again, this is the relevant Chinese translation, but perhaps for the purposes of brevity, we'll continue on. So we would advise to extend the definition of confidential information to include not only the internal products, sales, services of the company, but also to all sensitive documents, financial information, as well as any information in terms of the customers, clients of the company. Additionally, as I mentioned before, for an employee working in the R&D or design of the company, we would add a clause which would, if they would use the employer's tools during the duration of their employment and on the employer's property, any patentable rights which they would be entitled to would be forfeit and would belong to the company instead of the individual employee. So essentially, this would not only last for the employment contract, but also indefinitely. So even after the termination of the employment contract, the patentable rights would be that of the company instead of the individual employee. Again, the relevant Chinese translation, but for brevity, we'll move on.
Because this you're going to share with them, so they will have also share how good you are.
Very good. Okay, so moving on from the confidentiality clause, moving to the non-competition agreement. Again, an employee will not be able to engage with any restricted business, directly or indirectly. We'll define restricted business in a little bit. Not only for the term of their labor contract, but for 2 years from the termination of such labor contract. Restricted business would be defined as any company engaged in the same products or services of the employer during or directly after the termination of the contract. We see at the end here, there's a geographical stipulation where it says inside the People's Republic of China, exclusive of the SARs and Taiwan. Now, this geographical stipulation will be generally, it will be taken into context whether or not it would be too onerous on the employer to put onto the employee. So it would be construed in regards to how big the employer is, where their services are engaged in, and the level, the relevant level of the employee within the business. So for the whole of China, this could be deemed too onerous on an employee. Could be that they only engage in one city in China, and for a non-competition agreement to have them not have a non-competition agreement for the whole of China would be deemed too onerous by the Labour Arbitration Commission. But again, these are just example clauses, so again, on a case-by-case basis, and we'll see how these would be construed. Okay, again, we'll share the PPTs, so we'll move on with the English. And in addition to the non-competition agreement, during the 2 years upon termination of the labour contract, the employee would be entitled to compensation between 20 to 50% of their monthly income. Usually, in practice, that would come down to 30% of their monthly income, as we found in Shanghai. So again, if the employee is not compensated due to the employer failure of compensating them for complying with the non-competition agreement, then they would not be obliged to follow the non-competition clause and would be able to engage with another employer. Finally, with the non-competition agreement, on the other hand, if the employee fails to perform the stipulations of the non-competition agreement, they would have to pay damages to the employer up to 6 times their monthly salary. Again, this is just a general principle. If the damage to the company from the breach of the non-competition agreement would be more than that of 6 times of the monthly salary, then the employee would have to remedy the difference for, you know, claims or additional damage to the company's reputation from the breach. Okay. Finally, moving on to distribution contracts. We're moving more into the commercial contract sphere here. So again, commercial contracts would be, again, where a company engages with a distribution company to effectively market and sell their product within a certain area for a certain time. And again, it's, I know I keep on saying it, but the registration or the extension of registration of a company's trademarks is especially important before engaging with a distribution contract, as the distributor will essentially be using the trademark of the company in order to better sell and market the product within the area. So firstly, registration, then on to distribution contract. Oh, sorry, my voice just gone a bit there. Okay, thank you. Moving on. So for IPR protection clauses within distribution contracts, we would stipulate that any use of the producer company's trademarks would only be allowed with the prior express permission of the producer, and the only additionally, the distribution company will not be able to use the trademarks of the producer company on their own products. So essentially avoiding any counterfeit products which the distributor company could use from the good name of the producer. Again, the relevant Chinese translation. As we've seen in the trademark licensing contract, underneath a distribution contract, nothing underneath a distribution contract would be constituted as trademark license or any other licensing out of IPR. So there'd be no commercial rights extended underneath a distribution contract. Additionally, and this is actually very interesting, the distributor would agree to not register any similar marks to that of the producer company during the length of the distribution contract. Again, avoiding any counterfeit products which the distribution company could gain from piggybacking of the good name of the producer company. And the final commercial contract we'll look at today is OEM supply contracts. So this is where a buyer would engage with a manufacturing company in order to design and essentially produce their products for them. Now, under these contracts, essentially the buyer would supply the manufacturing company with the design molds as well as blueprints of their products in order to produce them, of course. So it's essential under these contracts in order to create clauses in terms of the protection of the buyer company's trademark and copyright, as well as stipulate the ownership of the blueprints and the design molds. So we'll look at some examples here. So for the buyer, we see the exclusive and absolute ownership of all copyrights, blueprints, design molds in the contract, in the OEM supply contract would be that of the buyer. Essentially, the safekeeping of the blueprints and molds so they don't become within the hands of people who are not entitled to them in the OEM, as well as the use of the design molds as well as the blueprints would only be used for the purposes set out in the OEM, so only for the purposes in which the buyer has permitted them. Additionally, the buyer is entitled to ask for the blueprints and molds return at any time during the OEM supply contract. This is to avoid any misuse of the blueprints and design molds, whereas the old design molds and blueprints would potentially be used to create counterfeit products by the manufacturers. You have the confidentiality clause, so all information within OEM supply contract would be kept confidential and not given to any third party without, of course, the express written permission of either party to the contract. And again, this would last the duration of the OEM supply contract, as well as 2 years upon termination, which again would allow for the product cycle of the manufactured product to finish. So essentially providing effective confidentiality for both the manufacturing process as well as the manufactured product. Again, Chinese translation, but we'll share the PPT later. So, general conclusions. So, again, we looked at some preventative measures, registering your trademark, of course, paramount to importance, or extending the registration of the trademark. But in addition to registration, it's important to add additional contractual clauses within day-to-day contracts which a company would be engaged in. We saw rather how vital these clauses can be in effectively protecting the intellectual property of the company. Next, we have foresight. So we see the future relationship, future issues of these contracts. So we see that certain intellectual property within these clauses not only lasts for the duration of the contract, but also perhaps 2 years after or indefinitely. So we see that even after the termination of the contract and the clause, the property of the company would still be that of the company and not of the distributor, the manufacturer, the employer, or the employee rather. Finally, so we looked at some standard commercial contracts as well as employment contracts here, but with adding some intellectual property protective clauses, we can raise the standard contracts to effective contracts which better protect a company's intellectual property rights in China. So for me, that should be it. And if there's any questions, I open the floor. Thank you.
Is there any question?
Yeah, for me. At the beginning of the presentation, you mentioned the difference between exclusive and sole license about the trademark license agreement. I didn't really understand the difference. Do you maybe have kind of an example? Because also the sole license, there's no third party, and so they cannot share the product with other people, so it's very exclusive. It's only between two people, so I don't really see the difference between the exclusive and the sole license.
Okay. I did kind of go through that very fast. For the exclusive one, it's exclusive because it's all commercial rights are exclusively that of the licensee, and the licensor essentially sells on all the commercial rights of the trademark. So it's exclusively the license of the licensee. With the sole, it's both, again, maybe it's a naming issue, but it's the licensor and licensee in the sole. So it's those two parties, no other parties. So it's solely those two parties. If that.
Thank you. Is there any other question?
Yes, I also have a question. Because sometimes some foreign invested companies, they went to China and they made contracts with other companies, but at the time they haven't registered their trademarks in China.
Yes.
So if it's possible to put some of the trademark these issues in the contract to protect them, and even if we haven't registered now.
So you mean put protective clauses of a company's trademarks before they've registered their trademarks?
Yeah.
No, impossible. Firstly, to register their trademarks, and then as an additional protective shield within commercial contracts to further protect from external parties such as producers, distributors, manufacturers like this. So firstly, registering or extending the registration underneath the Madrid Protocol, and then going on to additional protection.
Thank you. Any question from all our friends linked from Remoto? Okay, thank you so much, Shane. See you next time.
See you.